Our topic for today is Criminal Court Workshop for Allegheny County. And this program is hosted by the Carnegie Library of Pittsburgh, as well as the Allegheny County Law Library. Jess or Ms. Horvath?
You want me to go? Okay, hello and welcome to the Criminal Court Workshop. My name is Patty Horvath and I am the director of the Allegheny County Law Library. We are hosting this workshop as part of our mission for equal access to justice and community outreach programming for the residents of Allegheny County and the surrounding areas. I'm going to give it over to Lori, who collaborated with the Pennsylvanians for Modern Courts and the Carnegie Library to bring you this workshop.
Hello, my name is Lori Hagan, and I'm one of the reference librarians as well as the community outreach programming librarian here at the Allegheny County Law Library. And on this slide, you will see our, does it have our hours? If you go to our website, acllib.org, you can find out our hours, address, phone number, email address, and anything else that you would need to know. You could certainly call us at 412-350-5353. That's our main phone number. We are able to assist you with legal research, but not legal advice. Thank you, and I turn this back over to Tom. Thank you, Tom.
Welcome, Jess. Could you introduce your library, please?
Absolutely. Hi, everyone. My name is Jessica Bayless. I'm the Civic and Social Information Services Librarian with Carnegie Library of Pittsburgh. Civic CLP is a brand new initiative and is your place to learn about civic life and the importance of the First Amendment through library programs, services, and information resources. And it is my honor to collaborate with the Pennsylvanians for Modern Courts as well as Allegheny County Law Library on this program. Hope you enjoy.
Next slide. We'd like people to know that we're going to pursue a series of workshops with the Carnegie Library and the Allegheny County Law Library. March 2nd, we're looking at family court. April 6th, how to administer an estate. And May 4th, court basics in Allegheny County. So we urge you to check our Facebook and to go to pmconline.org for more information. Pennsylvanians for Modern Courts is the only statewide nonprofit, nonpartisan organization dedicated to ensuring that all Pennsylvanians can come to our courts with confidence that they will be heard by qualified, fair, and impartial judges. We work to make Pennsylvania courts accessible to all residents. We educate residents about their courts. That's what we're doing here today. And we advocate for judicial reforms. Our presenters today. Judge Alexander Bicket. Judge Bicket is a 1988 graduate of Duquesne Law School. He practiced civil litigation with Zimmer and Kuntz, PLLC, for 23 years. He was first elected in 2011 to the Allegheny County Common Pleas bench, where he first served in the family division. Last year, 2021, he won retention election for a new 10-year term on the court. Currently, he serves in the criminal division. Attorney Joseph A. Paletta. Joseph and I graduated from the Duquesne Law School in 1985. He has practiced law for over 30 years. Currently, his solo practice specializes in criminal defense, as well as medical and nursing license defense cases. We encourage our viewers to ask questions of both Judge Bicket and Attorney Paletta by placing them in the chat. Our agenda today will be looking at criminal procedure in 3 steps here in Allegheny County. First step will be investigation and arrest. Step 2, the magisterial district court, preliminary arraignment and preliminary hearings. And in step 3 will be the Allegheny County Court of Common Pleas. We'll look at discovery, pretrial motions, trial, guilty pleas, and appeals. Step 1, investigation and arrest.
Thank you, Tom. At this time, you will see on the slide in front of you a diagram that describes the state court system in Pennsylvania, the state court system in Pennsylvania. The cases will criminal cases will typically start out at the magisterial district courts. Then if a case is held for a higher court, it will move to the common pleas court. If a conviction occurs, then the case can be appealed to the Pennsylvania Superior Court. And the Pennsylvania Commonwealth Court is really not relevant to our discussion today, but after the Pennsylvania Superior Court, another appeal can be taken or requested to the Pennsylvania Supreme Court. The only court that is above or higher than the Pennsylvania Supreme Court is the United States Supreme Court. Tom or Debbie, do you have any questions before we move on to the next slide?
No, sir.
Okay, so as Tom Bailey said, I am a criminal defense attorney. I have been so for 30 years, and I'm going to describe to you traditional or the typical protocol here in criminal cases. So traditionally, an arrest can occur or a criminal prosecution can be initiated by what we perceive as a traditional arrest, just like you see on TV. Handcuffs are applied, someone is taken to jail, and then the criminal prosecution will be initiated from there. But not in all cases. For example, a typical driving under the influence prosecution will be initiated by a stop and testing for DUI. And after that testing procedure is done, instead of taking a defendant to jail, typically in a DUI case, for example, the defendant is released to someone who can pick them up, the defendant being the person accused or arrested, and later on a summons will be mailed to them so that they do not have to go to jail initially. Any questions about that slide?
Nope.
So on this slide, parties and grading of criminal charges in Pennsylvania, the prosecution is the Commonwealth of Pennsylvania. The state representing the citizens of the Commonwealth, they initiate prosecutions and will prosecute or bring the case against a defendant who is the accused. There are essentially 4 levels or classifications of offenses. The most serious case is a homicide case. And I know that Judge Bicket has sat on and overseen homicide cases in his courtroom. He can speak to that more specifically or in greater detail than I can. The next level, which is less serious than homicide, but still very serious, are felony cases. Typically, felonies are crimes involving firearms or aggravated assault when serious bodily injury occurs, and a theft of any vehicle, motorcycle, boat, car, that will be charged as a felony. A conviction of a felony can affect a defendant for the rest of his life regarding potential employment and other rights. The next level below felonies is misdemeanor. Misdemeanor conviction will go on a defendant's criminal record following a conviction. A defendant will not lose the same rights that they will lose being convicted of a felony, but it still goes on one's criminal record. And if, for example, applying for a job, if you have 2 candidates with exactly the same qualifications, one with a misdemeanor and one without, obviously you're going to take the candidate without the misdemeanor. So a clean record is a very important thing. The last and least serious criminal offense there is are summary offenses. Those are generally or can be handled by magisterial district judges. and are normally punishable by a fine. They can be punishable by up to 90 days in jail, but frequently that is not the penalty imposed. Under the criminal code, it is the equivalent of a speeding ticket.
I guess the only question I have for you is you made reference to these are for life, but there are methods of having records expunged. So people should know about that, right?
That's correct. That's a great question. Some prosecutions are resolved through a pretrial diversion program called ARD, the Accelerated Rehabilitative Disposition Program. If one has the opportunity to have their case resolved through ARD, that's a great opportunity, and an expungement or your record being erased accompanies the completion of ARD. The only other way to have a conviction removed from one's record would be a pardon from the governor. Does that answer your question?
Yeah, but conviction of a felony it requires a pardon. But I do not believe, I think most misdemeanors can be expunged by submitting various paperwork.
If the case can be resolved through a pretrial diversion program such as ARD, yes, but a conviction of a misdemeanor will remain on one's record unless there's a special disposition such as the ARD program.
I think we also have, this is Judge Bicket speaking, and we also have the Clean Slate Act, I think, where misdemeanors after a certain period of time, and I think that time is very limited, gets automatically expunged by the Department of Court Records. I think that's what you're referring to, Deb.
Yes, thank you, Your Honor.
Thanks.
Okay.
Anything else regarding that slide?
No, sir.
So I guess we can go on to the next slide. This next slide it shows the protocol for a criminal prosecution. The investigation and arrest is the first stage. When we refer to investigation, what we are referring to is sometimes criminal prosecutions or a criminal act is not observed by the police or a witness. Some investigation must occur before a crime or a prosecution can be charged. So after that investigation, then the arrest can occur again through either the traditional arrest with handcuffing the defendant, going to jail, et cetera, or through summons, as we discussed in the earlier slide. The next step is the preliminary arraignment. Preliminary arraignment is where a defendant first goes in front of normally a district judge, and the district judge will impose a bond. There will be a bail hearing, and for every criminal case, a bond must be imposed. That bond ensures the appearance of the defendant at all future court hearings. And a bond can be anything from what's called ROR, released on your own recognizance, which is simply your promise to appear at all future court hearings, to an unsecured bond where a district judge can say, okay, I'm going to release you on $5,000 of unsecured bond. One is released without having to post that $5,000, but if any hearings are missed in the future, you're incarcerated. You must post the $5,000 before you can be released. Or a monetary bond of, let's say, $50,000 straight, or a non-monetary bond with conditions. For example, we're going to release you without having to post any money, but for example, you must be fingerprinted and you can have no contact with a victim in the case. At the preliminary arraignment, a defendant will also receive paperwork regarding the charges, and then we go to the preliminary hearing. The preliminary hearing is the first opportunity for evidence to be presented against the defendant. And that occurs in front of a magisterial district judge. And it is also an opportunity to cross-examine any witnesses against you. And this is also an opportunity to plea bargain cases down from crimes that are originally charged to something less, perhaps even summary offenses, and have it resolved at the district judge's office. Very significant stage in the criminal prosecution process. Any questions on that so far?
Joe, can I interrupt you?
Please do.
Again, this is Judge Bicket. You know, I know that one thing that's on a lot of people's minds is the issue of cash bonds and how unfair that can be to certain defendants in the criminal justice system. And I think that there is a misconception sometimes as to how many defendants actually are on cash bonds. And I know there's a movement afoot to get rid of cash bond and to institute other forms of bail or bond so as to ensure that defendants show up to hearings. I will say this, at the court of pleas level, we have motions every single day with folks who are incarcerated as a result of an arrest, who were given cash bail by the district magistrate at the preliminary arraignments, and are now asking to modify that so that they can be released. And every day, either I or Judge Borkowski sit on these motions. And I would say that 90%, 95% of the cash bonds that were instituted at the district magistrate level are reduced to ROR bonds, in other words, release on your own recognizance, with certain conditions: report in person to probation or pretrial services, and to undergo a mental health or drug and alcohol evaluation, depending on what's appropriate based upon the facts. But I wanted to clear that up because I know that folks are concerned about it, and rightly so, that people who don't have money at this stage of the proceedings end up being incarcerated, and those that do have money end up being able to make bond and get out of jail. Thanks, Joe.
There are some new rules proposed by the Supreme Court's Criminal Rules Committee to standardize, I will say, some of the bail and detainer requirements. They're out for comment right now for lawyers and the public. They're on the Supreme Court's website. But yes, so you're more than welcome to comment. They're due to the court by March 8th. I'm going to interrupt you one other moment and say that PMC has a bail watch program that it has just started up in Pittsburgh under Tom's guidance. And so if anybody is interested in finding out about that bail watch program, please reach out to Tom in the chat or afterwards, through our website. Thank you.
Sure. So just to briefly finish up this slide, the next level where something of substance will occur is the trial level. That level will be addressed in greater detail by Judge Bicket in the third step in this process. But a trial is, that's what you typically know from television, where you can have a jury trial or a non-jury trial where the judge also functions as the jury, in addition to imposing a sentence. The sentence is the last step in the criminal process. That is a penalty that is imposed following a conviction. Judge Bicket can address that in greater detail later on in this presentation. Any other questions regarding this slide?
No, thank you, Joe.
Judge
Joseph.
Bicket, anything to add here?
No, not yet. Thank you.
Okay. This next slide regarding custodial detention and arrest, I could spend this entire presentation just focused on this particular slide. There's just so much information regarding this. I'm going to let you each read everything that is on the slide. There's something that I do want to address, and we're limited on time. A very significant event here at the time of a stop or an arrest is, and this is also, there's great public concern about this, the consent, the search issue and consent to search issue. Frequently, the police do not have a right to search you or your car or your home. As a matter of fact, a home cannot be searched without a warrant unless there's probable cause and something else called exigent circumstances. What I'm trying to tell you is the police can circumvent these requirements by asking you for permission or consent to search either your vehicle or your home. No one is required to give consent to search either your vehicle, your home, and sometimes even your person, depending on the circumstances that I do not have the time to get into right now. But if a police officer asks you if he can have consent to search, for example, your automobile, you are not required to give consent. Although many people hear the question, may I search your vehicle? They hear it as, I want to search your vehicle, and since you're a police officer with a badge and a gun, I must consent to that. You do not. You can say, no, I do not consent. And if a search continues anyway for reasons, good, bad, or indifferent, that issue can be addressed at a later time if a criminal prosecution is filed against one.
There's a question in the chat about, isn't probable cause very broad?
Probable cause has a very specific technical definition. Yes, it can be broad. However, there must be specific facts and circumstances that a police officer can point to before they have probable cause either to arrest or to search. And in circumstances where a vehicle, for example, is secured or locked in a legal parking spot, and a police officer cannot just search a vehicle. There are some exceptions to that. If a vehicle, for example, is going to be towed for whatever reason, then an inventory search can be done. But aside from that, police would need a warrant to search a vehicle. Sometimes, generally, there's an automobile exception that is too complex to get into in this presentation, but just do not consent if you do not have to. That's the bottom line. Do not consent. Secondly, to search a home, a warrant is required 99% of the times. Okay.
So just to jump in there, Joe, and to answer the question a little bit more in detail. Probable cause is not as broad as you think it is. Probable cause is probably the most specific reason to stop a car or to have a search warrant executed by a judge to search a car or search a house. Reasonable suspicion is probably the more broad concept, which allows law enforcement to stop and continue an investigation. But you cannot search, I don't believe, Joe, based upon reasonable suspicion. Probable cause is needed for a search warrant, which, by the way, is the default apparatus or vehicle to search a house, search a person, search a handbag, and search a car. Generally speaking, the rule is you need a search warrant. There are exceptions, which, as Joe said, probably too detailed to go into. But reasonable suspicion to pull over a car is much broader than probable cause to arrest somebody. Go ahead, Joe. Sorry.
No problem. Thank you. Vehicles have their own entire line of cases. Probable cause to stop a vehicle can be as simple as if someone is speeding and a police officer stops you for speeding, they have probable cause to stop your vehicle. If you run a red light, if you run a stop sign, that's probable cause to stop because you're violating a law, a law of the vehicle code. Now, whether things can go further than that, whether things can go south from there, that requires more information, more specific information. I saw something regarding a comment regarding the smell of marijuana. Well, that's very interesting because the case law, Judge Bicket can address this also, but the case law is changing in this area. So I don't really want to comment right now because things are sort of in flux. Judge, is that accurate?
That is, there was a case that came down, Commonwealth versus Alexander, I think it was, that said it's no longer an exception to the search warrant rule to search a car when you smell marijuana in the car. You need more than just a smell of marijuana to search a car without a search warrant. You need, bloodshot eyes, you need furtive movements, you need a whole lot of other factual issues or factual scenarios to exist before you can search a car. So it's, in a sense, goes to the movement as we see it today with the decriminalization of marijuana. And generally speaking, in the old, well, not generally speaking, but in the old days, the smell of marijuana provided law enforcement with an exception to the warrant rule and allowed them to search the car without consent.
I mean, and it goes without saying. So, with respect to marijuana, with respect to liquor, I mean, if you are, driving erratically, right, that is an example of a reason why police could pull you over. So there has to be, it's not just the smell wafting from the car, but maybe the car is going side to side and endangering not only you, but the other people on the road as well.
Right. But bear in mind, Deb, that to pull somebody over for violating a stop sign, not putting on a turn signal, is the purpose of the stop. And that doesn't give law enforcement the opportunity, once the stop has been made, to pursue other areas of investigation that they think may produce a firearm or drugs or contraband. And I think that law enforcement, oftentimes, based upon my experience, will pull somebody over for a minor traffic offense and then conduct an additional investigation which has nothing to do with the initial stop.
If I may add just one more thing very quickly, because this is very significant and happens frequently. If as Judge Bicket said, someone is, if a driver is stopped for speeding or running a stop sign, some sort of vehicle code violation, and for example, a ticket is issued for a violation of that vehicle code section, and then the police officer says, hey, by the way, may I search your vehicle? The answer is always no. The answer is always no. But many people feel as though they have to, that the police officer's question is more of an instruction or an order. The answer is no, and you're within your rights as a citizen to not provide consent. That's all.
And the following question, or the question preceding that, is to the law enforcement, am I free to go? Because certainly with a stop less than reasonable suspicion, which is a welfare check or an investigatory stop, you're not obliged to remain in police, not custody, but remain with the police. And I think the question always should be, am I free to go? And generally speaking, on an investigative stop or welfare check, the answer should be yes, but law enforcement won't offer this as an alternative to staying and answering questions.
Can I ask at this point that, great comments, or could I ask that we move on so we can get to some of the other material, please?
Joe, move on.
Okay, you have a right to a lawyer. If you cannot afford a lawyer, one would be presented to you. You also have a right to represent yourself. I personally, as a criminal defense attorney, would not recommend that. Judge, any comments on that?
No, and one of the things that I really like about the criminal justice system is that, in fact, you are entitled to have a lawyer represent you in the system. And I will say this, that we have a very robust court appointment process in the criminal justice system. We spend over $1 million a year, I believe, on court appointments. And to the extent that anybody wants to represent themselves in the criminal justice system, us judges colloquy them, ask them very detailed questions, and provide them with very, very detailed advice or consequences that they may find themselves engaging if they in fact decide to represent themselves. Because once you have determined that a criminal defendant wants to represent himself and that he understands what's going to happen when he does so, he's held to the same standards as a lawyer. And so he can't come back later and say he didn't know the law, he didn't know the process, he didn't know the procedure.
So I think we had a lot of questions, so I would suggest we move on.
Okay, step number 2, magisterial district courts, including preliminary arraignment and preliminary hearings. On this particular slide, this is just a factual slide with a picture of the Pittsburgh Municipal Courts building, which is literally underneath the Liberty Bridge. That's where all City of Pittsburgh cases, where all the preliminary hearings occur. And for City of Pittsburgh cases or arise out of arrest by City of Pittsburgh police officers, you can please note the websites. Additional information can be provided, more detailed information at those websites if you would like to learn more. Magisterial district judges, they hear, again, the first step, the first stage in a criminal prosecution. They hear preliminary hearings in addition to doing a number of other things that we have already touched on. Magisterial district judges, MDJs, do arraignments, they impose bonds, and they oversee preliminary hearings, which is, again, the first opportunity for evidence to be presented against the defendant and witnesses to testify against the defendant. Anything else on that particular slide, which is just informational?
Sure.
Okay, we again have touched on this particular slide regarding bail hearings. Everyone who is arrested for a crime and is being prosecuted, they are entitled to some type of bail. Judge Bicket has already addressed the issue of cash bonds. Judge, anything else from this particular slide?
Joe, why don't you address the issue of bond with respect to homicide cases?
Bond with respect to homicide cases is a unique phenomenon, because everyone is generally entitled to have a bond set to ensure one's appearance. However, in certain cases, an individual can be held without bond, and that's really only in the with respect to the crime of homicide. In a homicide case, if a bond is imposed, that bond is frequently very high. Judge, I really don't know what else to say regarding the homicide. It's its own specific animal phenomenon, and bond is usually high if a bond is imposed at all.
Yeah, generally speaking, it's not imposed because of the threat to society, and the district magistrate and or the common pleas court judge who hears it 72 hours from the preliminary arraignment will address that.
Unless there's anything else, next slide.
Joseph, I would suggest that we skip ahead to the preliminary hearing slides, because the bail has been covered. There you go.
Very good. Preliminary hearings. The preliminary hearing level is you could read general information regarding preliminary hearings on this slide, but preliminary hearings from a practical standpoint are very, very important, because a number of things from a practical standpoint could be accomplished. Number one, a defendant can have a hearing and hear and see the evidence against them. And this evidence can be recorded by a court reporter. And that transcript of the preliminary hearing can be used later if there is a trial in order to compare the testimony of a witness between the preliminary hearing and the trial. And if that testimony changes, obviously we have a credibility problem. Preliminary hearings are also very, very useful for discovering more information about the case against the defendant. And we defense attorneys try to elicit as much information as possible at the preliminary hearing, even pushing the boundaries of what is permissible frequently, just to gain more information, because information is power when it comes to preparing a defense, etc. Preliminary hearings are also very important because it's the first opportunity to negotiate with the district attorney's office and the arresting officer, the police, regarding reducing the charges. What defense attorneys will frequently do, if there's an opportunity to do so, we will try to negotiate felonies down to misdemeanors, because a misdemeanor is, although it's still a crime, is not as serious, does not have the long-term implications. We will attempt to negotiate misdemeanors down to summary offenses to resolve the case in front of the district judge. So it's a great opportunity, number one, to gain information about the case, and number two, to attempt to negotiate lower charges or negotiate the case away completely.
One of the things I want to mention is that hearings before MDJs are not automatically recorded. And so there has to be a request at the hearing or even before the hearing that the defendant wants it to be recorded.
And that request will almost always be granted. Judge Bicket, anything you would like to add on that?
No, preliminary hearing transcripts are important at a later stage when the cases are held for court. In other words, the charges are held for court, which is the common pleas court, which is where I sit, because oftentimes they form the basis for petitions for habeas corpus, which I can talk about later, or for suppression motions.
Regarding this particular slide, I think I've touched upon this, Tom, is that correct?
Yes, if you could just address what prima facie is, please.
Okay, certainly. Prima facie is a legal term. What that means is that the prosecution has a very, very low burden at the preliminary hearing. All they have to do is provide evidence of that the crime was committed. Evidence that a crime is committed is basically fulfilling requirements. In order for a particular crime, you have to have element number 1, number 2, number 3. If the prosecution provides evidence of those basic elements without any regard to potential defenses, etc., that is establishing a prima facie case and can permit a prosecution to move from the lower magisterial district court level to the next level, the Court of Common Pleas, for a trial where a defendant would appear in front of a judge like Judge Bicket.
And in fact, if a district magistrate does decide that a charge has been presented and the evidence is not sufficient to make a prima facie case on each and every element, he can toss that particular charge, dismiss that charge. However, that does not preclude the district attorney's office from refiling it at a later stage.
Okay, and we didn't have any questions in the chat about this section, so I don't know quickly if anybody has any questions. I'm looking through. I don't see any. So let's go to the next section. Thank you.
So I think that this is my opportunity to either bore you or scintillate you. This is Judge Bicket again. After the arrest, the investigation, the arrest, and the magisterial district judges have dealt with the preliminary arraignment and preliminary hearing. If the charges against a particular defendant are held over for court, that court is me, the Court of Common Pleas. We have 4 divisions here. The criminal division is the one that I sit in and the one that we're talking about today. And the process is simple, although sometimes can be protracted, and we are working on that right now to make sure that, in fact, if there is an option to limit the amount of time it takes from a preliminary hearing to getting a court date with a judge, we can do it. Generally speaking, once the case is held over for court, there is a formal arraignment as opposed to a preliminary arraignment. And at the formal arraignment, all the materials discovery is supposed to be turned over to defense counsel, the police reports, and any other materials that form the basis for A, the arrest, and the charges, B, the charges being filed. And at that point in time, a pretrial conference is scheduled in front of a judge, which generally means that the judge is not there, but the staff is there, and a court date is set up to address these charges. We're trying to streamline it right now so that there's no gap between the case status conference where you get assigned a date and a judge, because if people are incarcerated, it means they sit in jail for longer, and there's no reason for that. So at the time that we get the cases, as a judge here in the criminal division, I normally get confronted with a number of issues that arise from the investigation, that arise from the preliminary hearing. Generally speaking, one of the most common motions that I get to hear out of the gate once I have been assigned a case from the pretrial conference is that a defendant will file a motion called a writ of habeas corpus, which essentially just means let the body go. There was not enough evidence at the preliminary hearing to on each and every element of each and every charge to hold this charge or these charges over for court. That will spawn a hearing, and at that time, the Commonwealth has another shot at either supplementing the record or, if they choose not to do that, to just rest on the transcript of the preliminary hearing. So they're very hard to win for defendants, but it is a negotiating tool to show the district attorney's office that the defense or the defendant believes that the evidence is really very slight. And even though it may keep the charges pending in court of common pleas, it's not going to win a trial, because a trial, the burden of proof is beyond a reasonable doubt. Whereas to hold the charges over, all the Commonwealth needs to do is to provide evidence on each and every element of each and every crime that would give you a reasonable inference that there was enough evidence to actually go to trial, but not necessarily win. So we have pretrial motions, the first one being a writ of habeas corpus, which is very common. The other one that I get a lot are suppression motions, saying that the search of the car was illegal, the search of the house was illegal, the search of the person was illegal. We've dealt with that. I make a determination after a hearing with everybody testifying who wants to testify from both sides as to whether or not, in fact, the search was good or the search was bad. If I decide that it was an illegal search, then I would grant the motion for suppression, and any evidence found as a result of that search would be excluded at trial. It's called the fruit of the poisonous tree. So the poisonous tree, of course, being the illegal search. The fruit is the gun or the drugs found in the car, or the gun found in a purse, or drugs in the house, or whatever. The Commonwealth, under the rules, I have to write findings of fact and conclusions of law and place those on the record. The Commonwealth has the right to appeal that if I grant the suppression motion and put them out of court, essentially, because they know that they, as a result of that ruling, cannot present evidence that they need to secure a conviction at trial. The majority of cases, and I think there's a slide here which indicates 60% plus cases are cases that end up pleading guilty. In other words, 60+% of defendants who come into the criminal justice system after a preliminary hearing where the charges have been held over end up pleading guilty. And generally speaking, what happens is that the defense lawyer and the prosecution, the assistant district attorney, will get together. They'll discuss the strengths and the weaknesses of the case, and most of the time reach an agreement that in return for a guilty plea on lesser charges, that the more serious charges with the more serious gradings will be dismissed. There's also an opportunity to not only agree to plead guilty to certain charges, but also to accept a certain sentence as a result of that agreement. However, not all guilty pleas do we have an agreement as to sentence. Oftentimes, a defendant will plead guilty to lesser charges, and the sentence will be left up to the discretion of the court. When it comes to sentencing, we have a lot of discretion as common pleas court judges. And we have sentencing guidelines. We have a standard range, mitigated range, aggravated range, and we can really do what we want as long as we place on the record under certain circumstances what our reasons for doing it is. The staleness of a record, the fact that there were no victims involved, and whether or not this defendant is rehabilitatable and is in agreement to go to drug and alcohol rehabilitation.
Skipped ahead. I wanted to go, you talked about sentencing, but typically that comes after a trial, right, or after an agreement. So we sort of missed the trial part.
Well, I was sentencing after guilty pleas.
Yeah.
So the remaining 30 to 40% of cases will go to trial. And trial means either a jury trial, which you are guaranteed by the Constitution of Pennsylvania, United States, for any crimes that have a grading greater than a summary offense. In other words, misdemeanors, felonies, and homicides. You can go to a jury trial, or you can request a non-jury trial and have the judge sit as the decider of the facts of the case, and then apply the law as he sees it to the facts, apply the law to the facts as he sees it. I would say 75, 80% of trials, in other words, about 40% of cases that go to trial, end up being in non-jury trials. They're much more efficient. Sometimes there are evidentiary issues that a judge would understand better than a jury would understand. They're not inflammatory issues for juries to understand and to deal with. And judges generally, defense lawyers believe, and prosecutors believe, will be able to sift through that type of evidence and not let bias come into it.
Your
So
Honor, I'm going to ask you a question about that. How does that happen? Is that an agreement that's reached between
Yes.
the defense counsel and the prosecutor?
yes, both sides have to agree. In other words, if the prosecution wants a non-jury trial and the defense wants a jury trial, it will be a jury trial, and vice versa, obviously. So just to go through this slide quickly, stages of the criminal jury trial. You decide to go to a trial by jury, then you have a jury panel brought into the courtroom, and 12 jurors are picked from that panel, plus 2 alternates, and they are picked through the process of asking questions of voir dire, is a better name for it, by the prosecutor and defendant to make sure that the jurors can be fair and impartial. The jurors, before they come into the courthouse, have filled out a questionnaire answering the most important questions that would relate to their ability to be fair or not. Once a jury has been impaneled, we have opening statements. The prosecution puts on their case first because they have the burden of proof. Obviously, any witness put on by the prosecution can be cross-examined by the defendant. At the end of the prosecution's case, there's an ability by the defendant to tell the judge, hey, judge, they don't have enough evidence, or it's so weak that it cannot possibly be sent to a jury because they can't possibly prove their case beyond a reasonable doubt. And so they make an oral motion for judgment of acquittal. Those oral motions sometimes are agreed to by the prosecution, who realize either before, during, or after their case that they haven't introduced evidence on a certain element of a certain crime, and they would agree to it. Otherwise, the judge makes the decision. Once that has happened, it's the defense's opportunity to present evidence and testimony. One of the important things there is that a defendant has the right not to testify. And the reason that a defendant has the right not to testify is that the defendant does not have the burden of proof. The Commonwealth has the burden of proof. And I tell the juries, all of us tell the juries, listen, the fact that a defendant doesn't testify cannot be held against him. You cannot infer anything from the fact that he chooses not to testify because, in fact, the Commonwealth has the burden of proof. Once the defense has put in their case, their closing arguments, I give my final instructions to a jury, tell them what they should do, what should guide them. They go and deliberate, and then there is a jury verdict. To the extent that there's a guilty verdict, there's sometimes a request, if the defendant is not in jail, to then have his bond revoked and put in jail pending sentencing, or if he's not in jail, I can make a decision that it's not necessary based upon the crimes convicted to put him in jail. A defendant has the right to a pre-sentence investigation, which sometimes I order because it helps me evaluate a defendant's social life, past criminal history, and any other issues that I think would be important when it comes to sentencing. One of the amazing systems about one of the amazing points about our criminal justice system is that any not guilty verdict is unappealable. Now, I know I'm from South Africa, and I know that guilty verdicts in South Africa are appealable and can be appealed and appealed and appealed and changed by appellate courts. In this country, once you are found not guilty, it is all over. Double jeopardy sets in, and you cannot be retried for the same offenses based upon the same facts. Sometimes at the end of these trials, we have what we call hung juries. Juries have to be unanimous in a criminal jury trial. If one person wants to vote not guilty and the other wants to vote guilty, then it's a hung jury. If the opposite happens, one wants to vote not guilty and the rest want to vote guilty, the same thing. It's a hung jury. Can the Commonwealth do anything about it? Yes, they can retry the case if they want to, or they can decide not to do so, and then the charges will be dismissed. Any
Your Honor,
questions?
I just want to interrupt you one other time.
Cool.
The jury trials are open, right? The public can come in and watch. You know, people could come into your courtroom if they wanted to observe it. Is that correct?
Absolutely. We have an open court policy, and certainly in my courtroom, and I can't think of any other judge in the criminal division who would ever prohibit anybody absent exigent circumstances. Let me explain, Deb, what the exigent circumstances are briefly. In sex assault cases, when a young victim is going to testify, for their comfort level, we will sometimes empty the courtroom and let them testify without the pressure of having a gallery full of spectators. But absent that, absent exigent circumstances, the presumption is that our court system is open and that everyone is always welcome.
The only thing I want to say to add to that is that you're welcome to the courtroom, but you cannot record, take pictures. Your cameras and phones have to be off.
That is exactly right. Anything else? Questions?
I don't see any yet in the chat.
I have a question.
Yes.
Okay.
If someone has been convicted and wants to file for clemency, how do they do that?
Well, if I understand you correctly, would be a matter that would be dealt with by the governor's office. Are you talking about getting a sentence reduced?
Yes.
Well, it could be dealt with by the governor's office. It could also be dealt with by me. So, for example, once there is once a sentencing has taken place, I tell the defendants that they have 10 days to file post-sentencing motions and 30 days to file a direct appeal to the Superior Court. They're entitled to a lawyer for both of those procedures. And if they could not afford one, I would appoint one for them. So on an issue of what's perceived to be an unfair and unjust sentence, they could file a post-sentencing motion asking me to reconsider my sentence and have a hearing on that. And I would either reconsider it and then change the sentence or deny reconsideration and keep the sentence the same. If I deny motion for reconsideration of a sentence, then I think that the defendant has an opportunity at some point, Joe, you can step in here, to approach the governor's office and request clemency.
Okay. So if they're incarcerated and serving time for that sentence, what do you do then?
Well, that's a great question. It depends where they serve time, then. And the reason that I say that is I lose jurisdiction as a common pleas court judge. If I sentence somebody to a state sentence, I lose jurisdiction over any parole or appellate issues with respect to that. If I sentence them to a county sentence, which is less than 2 years, then I retain jurisdiction and I can parole a defendant, in other words, give them clemency, I think is what you're asking, correct? Before or before their minimum sentence or at their minimum.
So if during the Fayette State Prison, you don't have jurisdiction, so who would have jurisdiction over that?
That would be the Department of Corrections and the Parole Board.
Okay. And what if you have been sentenced already and like this is a whole different matter. If you're sentenced and you already, convicted or paid the fine and served a penalty, whether it be like probation or whatever, but you want it off your record, you still have to file a governor's pardon or expungement, or can
you can file? I apologize for interrupting you, ma'am. No, you can file a petition to expunge the record, and I think it's more difficult for felonies because felonies you have to ask for a pardon through the governor's office, but anything less than a felony, you can ask for it to be expunged. However, as I said, there is a state bill that came into effect, and Deb can correct me on this, the last 2 or 3 years. COVID has made things difficult to figure out where we are, which actually requires the Department of Court Records to initiate the expungement. And you don't have to do anything about it.
Okay, can I at this point ask, please?
Wait, Tom, hold on a second. There are also organizations, nonprofit organizations that will help with expungement and pardons. One of those organizations is Pulse. It's PLSE, I think, .org. So, I'll double check and I can get that out to everybody. Also, like in Philadelphia, Community Legal Services helps with expungements. The Bar Associations, Allegheny County Bar Association, I know helps with answering questions like this and helps with expungements as well. Sorry, Tom, go ahead.
I'm asking, thank you, Ms. Davis, for your questions. Could we go to one more while we still have time? There was,
Sure.
I think, a question in the chat.
What is that question?
It was just could you give an example of a charge to the jury you give at the end of the jury trial? What's the purpose?
Sure. Well, it takes an hour, so I won't give you that example. The instructions to the jury at the end of the case is divided into two. First of all, I tell the jury, listen, you've heard the facts, and now it's your opportunity to go back and decide which facts are true. I'm going to tell you what the law is, and depending on how you find the facts, you have to apply the law to the facts. Very simple example. Deb Gross runs through a red light, and she gets stopped, and she gets cited for running a red light. She has 3 witnesses who say she did not run the red light. The Commonwealth has 3 witnesses who say she did run the red light. Those 6 witnesses, 3 from the defendant's side, that's Deb, and 3 from the prosecution testify in front of a jury. The jury has to decide, was the light red or green? Who do they believe? And I give the jury indication to what they consider as, can you hear me?
Yes.
What they should consider when evaluating the credibility of witnesses. So once a jury makes a decision, if they decide that the light was red and that Deb went through the red light, I say to them, as a matter of law, if you find that the traffic light was red, the law in Pennsylvania is that Deb Gross broke the law and you have to convict her. However, if you find that it was green, then she didn't break the law. And by the way, you have to find that it was red beyond a reasonable doubt, not just think it was red, not just speculate it was red. You have to find that it was red beyond a reasonable doubt. So I tell the jury, I give them pointers as to how to evaluate credibility. I tell the jury to make sure that they don't consider the fact that the defendant did or did not testify at the trial. I tell the jury how they should conduct their deliberations, and I tell them what to do once they come with a verdict, and I tell them that they have every opportunity to ask a question, that the foreperson should write it down and give it to my tip staff and give it to me. So that's generally speaking what I tell them.
And I want to encourage everybody to, if you get a jury summons, go do jury duty. It is truly an interesting and educational experience, and your participation is really valued by everybody in the system. So you know that. I know we are out of time, so I want to just briefly, I guess, the appeal is pretty quick. Your Honor, do you want to give it a one sentencer?
Sure. One sentence is every time I sentence people, you can be found guilty by a jury, or you can plead guilty, and I sentence on both situations, under both situations. And I tell them, you've got 10 days to file post-sentencing motions. You've got 30 days to file a direct appeal to the Superior Court. If you lose your appeals all the way up, the other avenue for recourse is what they call a PCRA. It's under the Pennsylvania, oh, come on, I'm getting old. Relief Act. It's for ineffectiveness of counsel, newly found evidence. It's under the PCRA. So yes, they have the right to appeal, go to the Superior Court, which the Superior Court has to take. And then if they want to take it up to the Supreme Court, they can ask for aliquota, which means that they're requesting that they hear it, but the Supreme Court does not have to take it.
That's really important. The Superior Court in Pennsylvania automatically will take an appeal. The Supreme Court does not, unless there's a death penalty issue, so everybody knows. Correct.
Or there's an important constitutional issue or issue that has been decided by different panels in different ways in the Superior Court level.
Okay, so I want to say thank you. Tom, take it away.
Thank you to Judge Alexander Bicket and Attorney Joseph Paletta for participating and presenting. Thanks to Jessica Bayless of the Carnegie Library and Lori Hagan and Ms. Horvath of the Allegheny County Law Library. Would you ladies like to discuss the...
Tom, I just want to say one second quickly. If anybody wants to review this presentation, it is recorded. It will be up on our website. We will also be able to send you the link, and we can send you the PowerPoint and PDF. Okay, and then Lori and Jess, I think you had some materials that you also wanted to talk about.
Yes.
Yeah, go ahead.
Go ahead, Jess.
I'm just sharing in the chat now. We have a book list that we put together, kind of a mixed bag depending on your interests. If you're just curious, lots of different topics and points of view, and then also a link to the Civic CLP webpage. There are ways that you can stay in touch by newsletter or text alerts, or just learning more about upcoming programs that we do like this. Lori.
Hi, I wish I had my link with me, other than I can type in our website. How's that? acllib.org is our website, and I spelled Ort instead of org. Sorry about that. But for the public, we do the programs that we've done with PMC that we've recorded. We've added those there so that people can look at them after our time today. I put together a bibliography, and it's available also under criminal law bibliography on our website. If you need help with that, you can certainly call us 412-350-5353. I'd be glad to help you walk through that and get there. So, but it lists the primary sources, which are the important ones that say what the law is, how it's being applied. The secondary sources get you to the primary sources, so they're important. But we are here. We have over 100 years together, combined legal research experience here at the library, which is pretty amazing. So, and we're open to the public.
Thank you. And I want to thank everybody who joined us today. Hopefully we answered your questions, but if not, please feel free to reach out to us after the program. Thank you, Your Honor, for your time. Thank you, Joe, for your time.
My pleasure. Thanks for inviting me.
Thank you, everyone. Hope to see you all at the next workshop on March 2nd. Family Court.
Yeah. Bye.
Thank you.